Friends, today we are going to discuss a very important subject of criminal law which relates to law of rape. Rape as such is not only a crime against the person of a woman that is victim, but it's a crime against the entire society. It destroys the entire psychology of a woman and pushed her into deep emotional crisis. It's only by her sheer willpower that she rehabilitates herself in the society which, on coming to know of the rape, looks down upon her in derision and contempt. Rape is therefore the most hated crime. It's a crime against the basic human rights and is also violative of the woman's most cherished of the fundamental rights, namely the right to life, which is contained in Article 21 of the Indian Constitution. The rape law do not, unfortunately, take care of the social aspects of the matter and are inadequate in many respects. It is said that present day's law relating to rape have their origin in 1736 in Britain, when Sir Matthew Hale, in his Historia Chrysostom Cornea, or in the other words, History of the Police of the Crown, presented common law rape doctrines which were immediately noticed to be hostile to the interests of the woman, as one of the requirements was to inform the jury during trial that rape charges were easier to bring but difficult to defend. Consequently, in a tide of law reform, this requirement was removed. The rule of corroboration, which was much stricter in a trial for the offence of rape than for other offences, was largely removed from the law. Rape is ultimate violation of the self. It is humiliating even in woman's life, which leads to fear and existence and a sense of powerlessness. It takes away her sexual autonomy. It's an act of violence which affects the psychological, emotional integrity and dignity of the victim. The Indian Penal Code 1816 is an enactment which has gone through various ups and downs in its journey of around 150 years. When it was enacted, approach towards women was different. So very few provisions were maintained in this code originally which could be said offences against women, but in the passage of time, as per the needs of orderly running society, several acts which were initially permitted due to the personal or religious laws, but in the passage of time or due to social, political or economic changes, were declared as crimes and prohibited thereby to exercise. For example, dowry death. Rape is such an offence which cannot be remedied by punishing the offender, but it needs a change in the mind of the whole society, which watches the victim with suspicious eyes rather than sympathy. Rape is not an offence against the human body, but it's offence against her conscience. This is the ultimate violation of the self. Approach of the judiciary has been commendable except on few occasions where it felt short of the aspirations of the society. Rape is an humiliating event in the life of a woman which breeds a chronic fear of the existence and deep sense of the powerlessness. It is said that a victim of rape undergoes two searing traumas, one that is the physical and another mental, that's from society and equally from the trial. Rape for a woman is deathless shame and must be dealt with as grievous against human dignity. However, rape of a woman at any age is a violation on the private person of a woman, but it becomes more shattering and diabolic when victim is a child. For a conviction of rape or rape, corroboration is not necessary. In Indian climate, to emphasize for the corroboration is not good. No girl or woman would like to throw light on any incident which is likely to affect her chastity. She is always afraid of being ousted from the society, from being chastited by her family members, friends, neighbors, etc. In the presence of all these factors, if the offense is brought before the court, then it must be accepted as true and not fabricated. In principle, the evidence of a victim of rape stands on the same footing on which the evidence of an injured witness, but the evidence of the victim of a rape should be given more importance. If the evidence of the victim does not unworthy of a credence as a general rule, then there is no reason to insist on corroboration except from medical evidence, where having regard to the circumstances of the case, medical evidence can be expected to be forthcoming subject to following qualifications. Corroboration may be insisted upon when a woman having attained majority is found in a compromising position, and there is likelihood of her having leveled such an accusation on account of the instinct of self-preservation, or when the probabilities factor is found to be out of tune. Now friends, rape is defined in section 375 of the Indian Penal Code. What section 375 says, a man is said to commit rape if he, number A, penetrates his penis to an extent into vagina, mouth, urethra or anus of a woman, or make her to do so with him or any other person, or B, inserts to an extent any object or a part of the body, not being the penis, into the vagina, the urethra or anus of a woman, or makes her to do so with him or any other person. C, manipulates any part of the body of a woman so as to cause penetration into the vagina, urethra, anus or any part of the body of such woman, or makes her to do with him or any other person, or D, applies his mouth to the vagina, anus, urethra of a woman, or makes her to do so with him or any other person. Under the circumstances falling under any of the following 7 descriptions: first, against her will; second, without her consent; thirdly, with her consent when her consent is obtained by putting her or any person in whom she is interested in fear of death or of a hurt; 4, with her consent when the man knows that he is not her husband and that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married; 5, when at the time of giving such consent, by reason of unsoundness of mind, of intoxication, or the administration by him personally or through another of any stupefying or unwholesome substance, she is unable to understand the nature and consequences of that to which she gives consent. Sixthly, with or without her consent when she is under 18 years of age. Seventhly, when she is unable to communicate consent. Now, there are some explanations added to section. Explanation 1 says, for the purpose of this section, vagina shall also include labia majora. Explanation 2 says, consent means an unequivocal voluntary agreement when the woman by words, gestures or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act, provided that a woman who does not physically resist to the act of penetration shall not by the reason only of that fact be regarded as consenting to the sexual activity. Then there is one exception added to this section which says that a medical procedure or intervention shall not constitute rape. Exception 2 says sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape. Section 376 prescribes the punishment for offense of rape. Now, section 376 reads as under, whoever, except in the cases provided for in subsection 2, commits rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 7 years, but which may extend to imprisonment for life and shall also be liable to fine. 2. Rape by police officers, public servants, members of the armed forces, management or the staff of a jail, remand home or other places of custody, staff of hospital, being a relative, guardian or teacher or a person in a position of trust or authority towards the woman, rape during sectarian violence, rape on a woman knowing her to be pregnant, or on a woman under 16 years, or on a woman knowing her to be incapable of giving her consent, or being in a position of control or dominance over a woman, commits rape on such woman, or on a woman suffering from mental or physical disability, or while committing rape causes grievous bodily harm, or maims or disfigures or endangers the life of a woman, or commits rape repeatedly on the same woman, shall be punished with rigorous imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and shall also be liable to fine. Therefore, in both the cases, the minimum of 7 years has been prescribed as the punishment. Now, Section 376A, which has been recently added, says, during the commission of a rape under subsection 1 or 2 of Section 376, such injury is inflicted which causes the death of the woman or causes the woman to be in a persistent vegetative state, shall be punished with a rigorous imprisonment for a term which shall not be less than 20 years, but which may be extended to imprisonment for life, which shall mean imprisonment for the remaining of the person's natural life or with death. 376B says, sexual intercourse by husband upon his wife during separation. A wife who is living separately under a decree of separation or otherwise without her consent shall be punished with imprisonment of either description for a term which shall not be less than 2 years, but which may extend to 7 years and shall also be liable to fine. Section 376C says, sexual intercourse by a person in authority, whoever being in a position of authority or in a fiduciary relationship or a public servant or superintendent or manager of a jail, a remand home or other place of custody established by or under any law for the time being in force, or women's or children's institutions, or on the management of a hospital or being on the staff of a hospital, abuses such position or fiduciary relationship to induce or seduce any woman either in his custody or under his charge, or present in the premises to have sexual intercourse with him, such sexual intercourse not amounting to the offence of rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 10 years and shall also be liable to be fined. Now, one more section has been added, that is after 2013 Criminal Law Amendment Act, that is 376D, which deals with gang rape. It says, where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offence of rape and shall be punished with rigorous imprisonment of a term which shall not be less than 20 years, but which may extend to life, which shall mean imprisonment for the remainder of the person's natural life and with fine, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. Provided that any fine imposed under this section shall be paid to the victim. Friends, with these words, we conclude today's discussion on the subject of rape.